My name is Joe Lascota, Director of Dealer Development for NIADA, also a Certified Master Dealer Instructor and the moderator for the new NIADA 20 groups. This morning, the issue continues compliance, the fun part of our business and the hardest one to understand. And granted, compliance is the one that will assure you longevity in the business place by complying with it. As rules change, I got to tell you, business practices must also change. I have the privilege of introducing a personal friend of mine. I never thought I'd say I had a lawyer as a personal friend, but I do. Tom Hudson of Hudson, Cook and Associates is your moderator this morning, and Tom will briefly introduce his panel of experts. Ladies and gentlemen, Tom Cook.
Hudson.
Hudson.
That's all right. That's close enough. Close enough.
Thinking hunger.
Lawyers in the morning at 8:30 in the morning. I'm surprised the room is not just packed. I'm not going to introduce my panelists. We are tight on time this morning. I'm going to ask you to rely on the descriptions of these folks' backgrounds that you'll find in the program. We're not going to tell you where we went to grade school, high school, undergraduate school, law school, all that kind of stuff. We're just going to get right down to it. What we're going to try to do, I've told each one of my panelists I'm going to give them 12 minutes. When it's 2 minutes to go, I'm going to wave a flag in front of them and tell them to wrap up. We've got a lot of meat for you this morning. We're going to try to save a few minutes at the end for questions. But please keep in mind, we're also going to have this afternoon an Ask the Counselor kind of session where you can go in and spend as much time as you want to with us. And I can't speak for everybody here, but for most of us, I think we're going to be around for the entire period of the conference. And feel free to buttonhole any of us and talk about legal stuff. I think I can make the offer on behalf of everybody. I'm going to start off with my partner, Patty Covington. Patty?
Hi, my name is Patty Covington and I'm with Hudson Cook. I'm a partner of Tom Hudson. Today I wanted to talk to y'all about compliance management systems. Most of y'all heard, compliance program, that's been a best practice for a long time, but the real new kind of best practice that is out there is compliance management system. Before I go into my remarks about that, I want to give you a little sort of background information on the CFPB. Pretty much probably everybody in this room has heard of the CFPB. That is our new regulator. That is the federal agency that is, it's been empowered to regulate consumer financial products and services. And I want to tell you a little bit about them because that'll put my comments into context and probably a lot of what's going to be said here today. Because they're the new kind of cop in town and they're a very serious and very aggressive regulator. They have auto finance very much on their radar, and they are looking because they understand that for most consumers, an auto, the vehicle purchase is either the second most largest purchase on credit that they do, or it's the first for a lot of folks. So they're very in tune with this issue. Just to give you a little bit of stats, I don't like to talk too much about it, but they have about 1,200 employees, and about half of them are lawyers. They are very focused on enforcement. They are very focused on making sure that creditors are doing the right thing. So they have put out, both in rhetoric and in their examination manual and in other materials, that they want those entities that are subject to their supervision and their enforcement, which is going to be everyone here is going to be subject to their enforcement, to have a compliance management system in place. And so what is a compliance management system? Well, it really is more of a compliance program on steroids, or a fancy word, as my partner Tom Hudson likes to say, for compliance program. So, the past, what we had in the past hasn't changed, but it has changed a little bit because it's evolved to be a little bit more complex, a lot more formal, and something rather than just you ought to have it, you better have it. Because if the CFPB comes knocking on your door asking about questions, they're going to expect that you have this in place. So in the past, the standard was really just doing the right thing, making sure you weren't breaking the law, treating customers, not having fairly and in accordance with the law. But the game has changed a little bit because not only is it doing the right thing, but you now have to be built to do the right thing. And what do I mean by that? That means you have to have a compliance program in place because the CFPB not only wants you, complying with the law, but they also want you reducing the risk of harm to consumers. So what does that mean? Well, that means the risk that you're going to violate the law, the risk that you're going to treat them unfairly or deceptively. So they think that the best way of doing that is having a compliance program, compliance management system in place. So that's why they're requiring this to be in place. So, what is it? Well, there's 4 components to a compliance management system. The first is that you have to have board and senior management oversight. So the board, and when I say the board, I'm talking about ownership. I'm talking about the folks that essentially everybody looks up to, who've got the final say on the business. Those folks have to be clued in on compliance, not just on the numbers, not just on the financial successes, but on compliance. They've got to be bought into the fact that compliance has got, it's got to go from the top all the way down. Then it also requires that these folks set the expectations for those that work for them. If it's going to be important to the folks at the top, it's going to be important to the frontline folks, because that's who ultimately they're reporting to. So those folks have to be clued in. They have to set some policy on compliance. They've got to set expectations for those under them. So the second component of it is a compliance program. And that's pretty much what we've all kind of heard and done, hopefully, in the past, which is you make sure you understand the laws that apply to your businesses, you put in policies and procedures that comply with those laws, and you make sure you train people. Now, the training element of it has also changed a little bit, because not only do your frontline people need to get trained on compliance, but your senior management, your folks at the top need to understand compliance. So they have to get y'all have to get some kind of training. Coming to these types of programs, that NIADA puts out. When NIADA puts out educational programs on compliance, on the requirements that are out there, both on the federal level and the state, that is a form of training. So the people at the top really need to understand what laws apply. You don't have to get into the nitty-gritty of them, but you got to understand the general concepts, because you need to then make those expectations to the folks that report to you. And you need to understand what compliance they ought to be doing. So y'all have got to be trained. The senior folks need to also be trained. The third component of a compliance management system is a complaint resolution program. And this is probably one of my favorite things to talk about. And it's my favorite thing because it really can be sort of, what keeps you out of trouble. Because most likely a consumer is going to come to you first to make a complaint. They don't really want to get you into trouble. They have no, real desire to go to the CFPB or to the AGs or to the BBB. They got better things to do in their life. But they come to you first and they log their complaint. So you have the ability first to take care of that issue with the consumer before it gets escalated to the Better Business Bureau, to the AGs, to the CFPB. So in keeping with that, a compliance management system ought to have a complaint resolution program, or should have a complaint resolution program. And what does that mean? Well, first of all, it's a formal process for logging complaints, for tracking complaints, for resolving complaints. And to some extent, having a reporting mechanism so it reports up to your senior folks, to your management, your board, about those complaints. Because complaints can be very revealing about potential issues in the dealership, in the finance side of the business also. They are, what the CFPB sees as harbingers. They are sort of these red flags of where there's potential problems. And you ought to manage those complaints, not only resolving them with the consumers, but figure out, what's being logged. Are you having a lot of complaints about a particular individual, about a particular part of your process, about a particular practice, or a product that you're selling? If you are, you ought to do what's known, it's called, the fancy word is root cause analysis. Why are those complaints happening? Go back, look under the covers, start thinking about why those complaints keep coming on these particular issues, and identify the problems and resolve them. Resolve them internally with your institutions and resolve them externally with the consumers, because that, again, is what the CFPB is expecting, that you not only fix the problem internally, but if you find that there's been a problem with the consumer, you make the consumer whole, fix the problem with the consumer. There are 3 words that I like to kind of throw out that are a theme for a compliance management system: prevent, identify, correct. Prevent is what a compliance management system is supposed to do: prevent violations of law, prevent harm to the consumer. You do that by managing your complaints, monitoring, and I'm going to talk about that in just a minute, monitoring what's happening within your dealerships. Identify. So you're identifying through the complaints, you're identifying gaps in your compliance programs, and then correct, that's that last one. Correct it internally and correct it externally with the consumer. The last component of a compliance management system is the auditing and monitoring component. So what's auditing and monitoring? You're probably thinking to yourselves, our shop is way too small to worry about auditing and monitoring. Well, it really isn't, because it doesn't have to be real fancy, it doesn't have to be real complex, but essentially you got to go in and test. You got to make sure that folks are doing what you say you're doing. If you have a compliance program, you have policies and procedures, from a business perspective, you want to make sure folks are doing what you tell them to do in your policies and procedures, because you're not going to be selling as many cars. You're not going to be getting as the F&I profits that you want to be doing. So you want folks to be doing what you say you're doing, and that's what auditing and monitoring are supposed to be doing. Essentially, testing. And if you find a problem, you're correcting that problem. Again, you correct it internally within the institution and within your companies, and you correct it externally with the consumer. I really can't say enough about prevent, identify, and correct, and about complaint management, because a lot of the problems that fall upon you via litigation or with your regulators, they really stem from initial complaints that a consumer has about some practice that you've got. Look at it internally, put policies and procedures around it, and make sure that the board, the senior folks, are clued in as to what's happening in compliance, because ultimately those are the folks that are going to be held responsible. And those are the folks that, when the CFPB comes looking, one of the first things they ask are, they want your financials. You know why they want their financials? Because they want to know if they're going to put a fine on you, what's going to hurt. They may not put you out of business, but they're going to put you close to out of business because they want it to hurt. Kent Marcus, who's one of the senior folks at the Bureau in enforcement, said, they want to make it very expensive not to comply with the law. And that's essentially what a compliance management system is intended to do, comply with the law.
Thank you, Patty. Mike Dunnigan's next. Mike and I talked a little bit about what he was going to talk about this morning, an interesting bunch of litigation developments in his state. Mike?
Thank you, Tom. I chose just at random some not necessarily related topics, and the only reason that I chose these particular topics is because these are things that actually have happened to one of my clients recently, and so these are real topics and real issues and things that I just want to bring to your attention. The first thing I want to talk about is the internet's a great tool, and many of you, I know, you probably use it in buying cars. Auctions have all got internet programs and everything. Well, one of the things that has happened that may not be quite as favorable to you is law firms, particularly plaintiffs and consumer law firms, are now having a big internet presence, and they are, in some cases, looking for business, and when one of your customers is unhappy with you, first thing they do now is they go to the internet and they start typing in bad car dealer or lemon car complaint or something of that nature, and then they get directed to quite often these law firms, national in scope, most of them, that are trolling for that kind of business. And here's the situation. I've had 4 of these probably in the last year, coming from the same firm, and that's how it all came about. And what happens first is my client gets a letter from this law firm saying that we found a violation. Sometimes they're specific, sometimes they're not, and just demanding a large amount of money to be paid because of the damage to their client, who was the dealer's customer. What we've found in dealing with these cases is they're not really interested in pursuing a lemon-type action or even any kind of a consumer action based on the condition of the vehicle, which is usually what the customer, what your customer, their client is complaining about. But what happens is once they get them hooked, they ask to see the paperwork. They want to see the paperwork. They scan the paperwork for technical gotcha, what I call gotcha violations. A lot of them are Federal Truth in Lending And they also do some unfair debt collection work, but they've got a violation that has statutory damages. Now, the statutory damages are fairly small. In a lot of these cases, say $1,000, relatively small. But that's not what they're really interested in. What these firms are doing is they're wanting to run up attorney's fees. So the longer you fight, the more you delay, the greater the attorney's fees that they're going to try to collect from you are going to be. And we found that they're really not, in many cases, interested in settling for the statutory damages and minimal attorney's fees. They're really trying to run it up. And of course, if the dealer who gets one of these either throws it away or decides, no, I'm just not going to capitulate, I'm going to fight it or whatever, just keep in mind that the clock is going to start running. And so one of the things that we have found that was effective in dealing with these, especially if there is a violation, I'll give you an example of one we had, was the dealer had, it was a buy here, pay here dealer, and on the contract they had put some pickup payments. Well, one of the pickup payments went beyond the second regular installment, which you can't do. And a very technical violation. Nobody was hurt, no financial damages to anybody, but nonetheless it was a technical violation. This law firm wanted a lot of money. Well, as soon as we saw that the dealer had violated it, we made a tender offer. Tender is a legal term of art. A tender offer for $1,000 statutory damages plus attorney's fees for sending this demand letter to cut it off. And we found that once we did that, we were able to get them to be realistic in what they wanted and get the thing to go away. There was a case recently out of federal court in Dallas-Fort Worth area where a judge actually threw out one of these cases by the same law firm, by the way, where a tender offer had been made, but they wanted to go ahead and litigate it anyway. Well, under Rule 68 of Federal Rules of Procedure, if you tender a judgment of what the maximum damages under that situation are, plus reasonable attorney's fees, that cuts it off. And I found that to be a very effective tool. We have a similar law in Texas for deceptive trade cases. A very effective way to get it settled and get it resolved, whereas if you do nothing or if you wait, the cost just goes up simply because they're running up the attorney's fees, which is their goal. So just keep in mind when you get one of those letters, you may want to mention to your attorney, can we just make a minimal tender and just resolve it that way, especially if the technical the gotcha violation is there and it's clear and it's in black and white, there is no defense for those, they're strict liability. So keep that in mind when you get one of these letters. Another topic I wanted to mention that we're seeing a lot of is the Service Person Civil Relief Act. And this can be serious stuff. There was an article in one of the trade journals here recently about a dealer who totally ignored the service person's plea for benefits and relief under the Relief Act. And the two things that you need to know if you're a lien holder is, number one, you can't repossess without a court order, and number two, you have to lower the interest rate to 6% from the date of active duty. Pretty simple stuff. And this dealer chose not to do either one of those. He didn't adjust the interest, and he repossessed the vehicle. Now, he is under federal indictment right now. So we're talking criminal charges, not just the potential civil charges, which could be substantial. So just be aware if you get a notice from one of your customers that they've gone on active duty, do your due diligence, check it out. We've also seen scams out there where people were claiming to be on active duty and they weren't. All they were trying to do was to buy time on their obligations. So do the due diligence, find out through Department of Defense, is this person, because you got their Social Security number, are they actually on active duty? And if they are, then you need to be prepared to comply. But just be aware that that law is out there. You may never see one of those cases, but then again, if one comes up, you need to be able to react to it appropriately. Next item I want to mention that has come up recently is the IRS 8300 cash reporting form. The IRS is doing audits out there of dealers. They're targeting buy here, pay here dealers who handle a lot of cash. The general rule is you take in over $10,000 in cash or cash equivalents from a person in a 12-month period. How are we doing on time?
You're fine.
Okay. Then you have to file with the IRS this Form 8300. And it's serious stuff because this is part of government's anti-terrorism, and also money laundering is the target of it. And so in addition to having some of my clients audited by the IRS to see if they had failed, and a couple of times there were inadvertent mistakes, then they end up paying a fine for the violation. But let me tell you what else is going on out there. In some cases, the feds and local police are doing operations where they're sending in folks who are obviously drug dealers or some type of other undesirable, who is offering and flashing around a lot of cash to a dealer to sell, to buy a Hummer or some type of exotic, and makes the statement, but you can't report this to the IRS. You can't file an 8300. One franchise dealer in North Texas a couple of years ago fell for the bait. He is now in federal prison. This is serious stuff, and there have been 2 other cases in North Texas I'm aware of where the offer was made, and it looks like there's going to be some legal proceedings coming up. So be aware, if someone tries to get you to violate that law, just tell them no, you're not interested. It's not worth it, because it may be a plant and there may be something going on. Next item I want to mention is the FTC Buyer's Guides. You may have read in some of the trade journals there was a sweep done by the FTC through a town in, I hope I'm not stepping on your toes here, Lisa, in Arkansas.
Hey.
They went through all of the dealers in that town. They found, I think, a third compliance, a third no compliance at all, and a third about halfway compliant. When I do internal audits for my dealer clients, one of the first things I do is I walk the lot and I look to see if you got FTC buyer's guides, the window stickers posted.
Got a minute, Mike.
Okay, and it's tough because you've got inventory coming, inventory going, you've got customer cars, you got for repair, you've got repos, you've got all kinds of new inventory just dropped off. And my recommendation to my clients is have a segregated area for all of those non-for-sale vehicles, that they don't go into the for-sale area until they have a buyer's guide on them, and use that as a way of controlling that, because that's a gotcha violation. There's no defense. And if FTC is indicating they're going to step up enforcement, then it's something you can expect. Also, our state Motor Vehicle Division, on their audits, they enforce it. So anyway, those are just some random topics, compliance issues I've run across in real life. I wanted to share them with you, and it's good to be here. Thanks very much.
When the FTC comes out with their new rule, it wouldn't surprise me to see them launch at the same time a bunch of those kinds of raids to try to emphasize the fact they've got a new rule out there. I asked Lisa what she wanted to talk about, and she said, I'm going to go back over the most frequent complaints I get from our real live dealers and talk about what I do on a day-in, day-out basis. Lisa?
Thanks, Tom. Yeah, I thought that, the questions that I field most often in my office, I thought would be what I would talk to you about today, kind of 2-minute quick tips on advertising, pricing, repossession, and bankruptcy. Obviously, we could spend hours on those, so two minutes or quick tips are going to be very quick. And I'm going to make it even quicker because I want to start out by saying, before I came here this morning, I had a phone call with my mom. She's in a nursing home, and she's had a couple of strokes, and it's really messed with her mind, and has some dementia set in. And so we always have interesting conversations every few days. And so I told her where I was this morning, and that I was in Las Vegas with a bunch of auto dealers and lawyers. And even she knew. She said, "That sounds like trouble." I said, "Yes, Mama, I think it is trouble." And I said, "I'm going to give a talk today." And I said, "What would you have me tell them?" And he said, "Well, I don't know, but, probably just to do right." And I know that sounds simple, but it reminded me of something that I give and I say a lot of times to the Arkansas Independent Auto Dealers Association when I speak there. I'm their counsel. And it does go back to, we can sit up here and talk about a lot of the rules, which are very important, and I don't mean to minimize any of them. But there are a lot, some of the rules are really technicalities. You have to check X, Y, and Z, or you have messed up. But the ones I'm talking about today are really more of a, they try to legislate morality a little bit. They make us try to be, we have to be good whether we want to be or not. I think that a lot of times if we actually do go back and do a best advice of just treating everyone the way that we know we ought to, the way that we would want to be treated, and treat everyone exactly the same, whether it's cash, credits, black, white, male, female, plastic, paper, doesn't matter, whatever they pick, you treat everybody exactly the same. And treat them to the level of someone you want to impress. Who do you admire? It might be the little widow who sits next to you at church. It might be Barry Switzer, who's coming up here in a minute. It could be your mama, your daddy, your grandmama. If you run these things that your practices by them, it's amazing how many of those technicalities you will actually catch, which kind of segues into my advertising quick tips. For advertising, both at the state and federal levels, they use a reasonable person standard. Who is that reasonable person? That's not Stephen Hawking and it's not Paris Hilton. It's somewhere in between. So a lot of times if you do have someone, have a lay person look at your advertising. I see a lot of times my dealers, they're getting a little more aggressive and it makes me a tad bit nervous with some of their promotions. You really get in trouble with things like free. What does free mean? That sounds simple, right? But is it truly free, or is there a catch to it? That there is going to be a little bit of money that's put out. Well, if there's money put out, it's not free. Is it included in the price of the vehicle? That's also not free. Some of the gimmicks also, at least they consider them gimmicks, are ones that give you a sense of urgency. There's an emergency sell-off. Well, why? What's creating that? This false sense of urgency. Some of the state attorney generals have tapped some dealers on that was misleading because there really wasn't a sense of urgency. The two terms that mainly get people in both federal and state under, we have unlawful or deceptive trade practices acts, is what is unfair and what is deceptive. And that's not an and, that's an or. So you can get tripped up by either one. Well, what is unfair? It seems somewhat subjective. And again, it goes back to that reasonable person standard. So I would encourage you to really look at your advertising. I think that for the most part, if you're completely honest and don't just put this stuff in fine print, we all do that too. And yes, that's important. But even if that fine print can be misleading, it's free, except you have to pay for it. Well, we all know that that's not true, and that you can get tapped for that. Pricing. There's a lot we can talk about with pricing, but the gist of it would be I recommend my dealers price a car and leave it alone. I'm not a proponent of risk-based pricing. I think that it gets you into trouble sometimes. And I think when you do these cash versus credit, it's one price when it's credit, it's one price when it's cash. You can't do that. It sounds easy because we're negotiating, right? But if it's a person who's really, a mystery shopper with the Bureau, it's also very easy for plaintiffs' lawyers. That's so easy to put a plant in there and catch someone at doing that. You don't have to do, and you only have to do that a couple of times before, wow, I've got a great case, and I can look at all the different things that you've done in your sales between cash and credit. Because what you do, the sale price that is in excess of what you quoted as that cash price is technically a finance charge, because that's what you've added on to that price to give them for financing. And then you can run afoul of usury laws and all sorts of things. With advertising and pricing, that's so easy for plaintiffs' lawyers to build a wonderful class action case, or attorneys general. So I would really encourage you to be very careful in those two areas. Another field that I get a lot of questions about is repossession. And it's funny, we kind of had a rash lately, I think, of issues in Arkansas at least, where we had one recently who a gentleman called and he got arrested for theft for repossessing a car. That was unusual, but we kind of got into some of the other situations. And when you get in a small town in rural Arkansas or rural anywhere in America, you have to be very careful. You can find yourself, he said, I didn't do anything wrong. And he's right. He didn't do anything wrong. But he still has to go through this process. And it's going to be expensive for him. He has to talk to people like me. He doesn't want to talk to people like me. So it caused a situation that he could have averted if he'd have done a couple of things differently. It is one thing to call the police and let them know, I'm going to repossess a vehicle. I'm not stealing this vehicle. Here is the vehicle I'm getting, and here's who I'm getting it from, and here's where I'm getting it from. It is another thing to say, I anticipate a problem. If y'all got a cop in the area, I would love it if y'all come by. We have that happen. There's not inherently something wrong with that, except now you have an officer there with a gun on his hip, and you're collecting a vehicle. Is that a peaceful repossession? And that goes to basic, state or common law. Is it a peaceful repossession? I'm not sure it is. I'm not sure it isn't. But it certainly gives me a little more heartburn than it would if the cop had not been present, armed and ready for a fight. Those just make things a little more difficult to defend. So I would encourage you to just be careful. Notifying the police is one thing. Having them there while you repossess is another. Use your forms. It's simple and it's easy. Your notice of plan to sell property, your explanation of deficiency or surplus. These are forms that should be a standard in your repo packages, and use them. When you don't use them, you have trouble. Especially if the person files bankruptcy, especially if the person files a lawsuit for something else and you didn't use your forms properly. That's something that is an easy checklist, and I would encourage you to do. Speaking of bankruptcy then, the biggest issue I'm getting into lately in fielding calls is about some really aggressive debtors' attorneys who are saying there's a stay in place and you have violated the automatic stay and all the nasty things he's going to do to you, and he's not sending you a Christmas card next year. Well, a lot of times under the new bankruptcy law, it's 2005, but still new to me, is there's not a stay that's automatically in place. So it's good to contact your lawyer and find out about these things, but don't just give back a vehicle immediately because you've got a nasty gram from a debtor's attorney. At least contact your lawyer and say, here's my situation, here's the case number, can you look it up? There may not be a stay in place. You may not have done anything wrong. You may not need to do anything with that debtor's attorney. Now, you don't need to just do nothing usually. You do need to call your lawyer and maybe have your lawyer visit with that debtor's attorney. But don't just hand over the goods because someone slapped you on the hand and said you did wrong. You may not have done wrong. That bankruptcy stay is not always automatic anymore, especially when you have those serial filers that we all know, and I would encourage you to just be careful about that. That's all I really had to say. You can thank my mama for the sermon I started out with, and I do think that if we do try to just treat each other right, we'd probably find we'll run afoul of very few laws, and in the end, at the end of the day, we'll probably all be more successful anyway than the guy down the street who doesn't care to do that. So thank you for having me here. I very much appreciate it.
Thank you, Lisa. We're going to turn next to, by all means. We're going to turn next to Sean Peterson. Sean is, all of you know Sean, he's NIADA's Federal Counsel for Legislative and Regulatory Affairs, and he's going to tell us what's going on in D.C. What a challenge, right?
Yes, always a challenge. It's an honor to be here with this esteemed panel, and poor Paris Hilton always gets picked on, doesn't she? A couple of items that are hot off the press, and I mean literally hot off the press. I took a telephone call on Monday from the FBI, the Internet Crime Complaint Bureau within the agency and the Cybercrime Bureau. This is, I guess, a compliance issue, potentially a compliance issue, but it's equally a dealer protection issue as well. There's a term of art that they have out there now called spear phishing. So your challenge this week is to use that term in a sentence. In essence, what spear phishing is a target by cyber criminals against a particular industry or an individual or company in that industry, where they are attacking your credentials to various internet sites. So for example, in an automotive industry, they have mentioned specifically that accounts with AutoTrader or Cars.com or eBay have been targeted by these cyber criminals, where they will send an email to you representing themselves to be one of these reputable companies, asking you to verify your credentials with that company. And they then get into your account, take your information off of those websites, and create mirror websites. And take the ads that you have posted on those particular company websites, and they have changed your phone numbers, changed your addresses, but yet represent themselves to be you. So when a consumer is calling about a particular car, they have made arrangements with that consumer to have money transferred to a particular location. The consumer thinks that that car is going to be shipped from your location to them, and then obviously that doesn't happen. So the FBI is very concerned about this from both perspectives, from the consumer protection perspective, but also from your perspective as well, protecting you. So we are working with, I've spoken last night with folks from eBay Motors and folks from Auto Trader and Cars.com to get some best practices that we can get publicized for you to make sure that you're protecting yourselves. The FBI recommends a couple of different things. One, don't respond to those type of emails. Obviously, look to see past history. If you get an email asking for credentials, that's probably a good sign that that's not legitimate. Very few companies, I would say, I'm not aware of any, quite frankly, where those companies will ask you to, in an email, to send information to them, particularly your credentials. Two, they have some suggestions out there about protecting your actual postings with the various companies. We're going to get some more information from them, but one of the things that they specifically mentioned to me that can be a protection to you is if you're posting pictures on these websites, you can watermark those pictures. And if they're mirroring that site, you now have pictures that say ABC Motors or whatever the case may be. Like I said, we'll get some more information from them here in the coming weeks, and we'll work with these third-party vendors to make sure that we get their policies and procedures and their practices out to you on tips that you can do to protect yourself from these types of scams. Spear phishing is your word of the week. The other thing that literally just came across last night is a guidance document that the CFPB put out. And it really dovetails off of what Patty just talked to us about, the importance of these complaint management systems and having things in place to protect ourselves. The title of this guidance document is Responsible Business Conduct, Self-Policing, Self-Reporting, Remediation, and Cooperation. This is the first document that I'm aware of that the CFPB has put out with two things. One, there are a couple of bullet points of things that they consider when taking an enforcement action and things that you might be able to do to limit your exposure with the CFPB. So I'm going to refer to that because I've only had a couple of minutes to review it a couple of times here this morning. But I wanted to point out a couple of different things that I think illustrate and emphasize the things that Patty's just talked to us about, how important it is that you've got these management systems in place. This is the why. This is why we preach this. The CFPB, in exercising its enforcement discretion, has said that we're going to look at four things in particular to give us a sense of the seriousness of the violations and whether or not we need to take a particular action. One is the nature, extent, and severity of the violations that the Bureau has identified. Two is the actual harm or the potential harm to the consumers from those violations. Three is a company's history of past violations. We talked a little bit yesterday about this consumer complaint database that the Bureau now has. So that's obviously going to be one of the tools that they look at in determining whether or not there is a past history. But they're certainly going to look to state attorneys general's complaint databases. There's cooperation agreements with most of the states and the CFPB to share that information. They'll look at BBB and other complaint databases as well. And four is the party's effectiveness in addressing those violations. The Bureau says that this is a document we want to provide some information to you so that you understand that these are some of the factors that we're going to take into consideration. But of course, this is drafted by attorneys. Kent Marcus is an attorney, former chief counsel for the state of Ohio, the governor's office. And I'm sure he had his hands in this. And this is filled with all sorts of reservation of rights. We do that all the time as attorneys. We want to make sure that our clients' interests are protected. You're engaged in that sort of conduct as well with your transactions. Notwithstanding these four principles, the Bureau is going to ensure that they've got the discretion that they feel that they need in moving forward with the prosecution. So, in addition to pointing out those factors, the Bureau has given a couple of different things that those companies that are potentially being investigated can do to mitigate the damage that they might face. One is self-policing. We've had some experience with this in some of our clients, and it's certainly got nothing to do with us per se, but I'll give you a little anecdote. We had a client that was investigated by the FTC several years ago, and this particular client had gone through a painstaking process to do exactly what Patty has talked about today. Put compliance policies in place and train their employees and make sure that all of their I's are dotted and their T's are crossed, and that the folks that work for them understand the regulations, the expectations. They also had a bunch of vendors that they worked with and made sure that their vendors were aware of that information as well. Notwithstanding that, this company received a significant number of complaints relative to their conduct. Most of the complaints were baseless, but there was a large number of them. It was something that we certainly had to acknowledge. Notwithstanding the large number of complaints and the fact that the FTC wanted to kind of peel the layers of the onion back and take a look at what was going on, they were able to demonstrate to the FTC that they had these policies in place, that they had this complaint management system in place, these compliance manuals and all the things that Patty's talked to us about. Everything was in order. At the end of the day, the FTC closed that investigation without any enforcement action whatsoever. And the feedback that we got, and again, it had nothing to do with us, it was all them. They were proactive in this before they ever needed legal assistance, was that the reason the investigation was closed because they had taken the effort to police themselves. They had the policies and the complaint management system in place where they were catching these things that all turned out to be not legitimate complaints. Here's what the Bureau says with respect to this self-policing or self-monitoring, self-audit. It reflects a proactive commitment by a party to use resources for the prevention and early detection of potential violation of consumer financial laws. So in considering this idea of self-policing, the Bureau says we're going to ask a couple of questions in considering what we should do with this concept. One, what is the nature of the violation or potential violation, and how did it arise? Was that an isolated act? Is it a pervasive act? How long did it last? What is the conduct significant to the party's profitability or business model? Two, how was the violation or potential violation detected, and who uncovered it? Did it come from an internal source? Did it come from an external source? What compliance procedures or self-policing mechanisms were in place to prevent, identify, or limit the conduct that occurred and to preserve the relevant information? And in what ways, if any, were the party's self-policing mechanisms particularly noteworthy and effective? Three, if the party's self-policing functions have previously been the subject of some type of supervisory examination by the Bureau or investigation by another regulator, what were the results of that investigation or examination? How has the party changed their self-policing practices since that investigation or examination? And number four, what is the party's tone at the top? Patty mentioned the importance of having the board, the owners, involved in compliance. And that's where it starts, and then the Bureau's back that up. What's the tone at the top? And how is that passed down? Is there a culture of compliance? The second factor that the CFPB has thrown out in this document is the idea of self-reporting. Now, this I think will have to be fleshed out a little bit. We don't certainly want to do any kind of admission of guilt, but here's a couple of things that they say with respect to self-reporting. Of the four categories, prompt and complete self-reporting to the Bureau of significant violations and potential violations is worth a special mention. Here's some of the questions that they'll ask with respect to that. Did the party completely and effectively disclose the existence of the conduct to the Bureau, to other regulators, and if applicable to self-regulators? Did affected consumers receive appropriate information related to the violations or potential violations within a reasonable period of time? Did the party report the conduct directly to the Bureau, and did they do so promptly? If it was delayed, what justification was there for the delay? And then is there, did the party proactively self-report or wait until discovery or disclosure was likely to happen anyway? For example, due to an impending supervisory activity, public company reporting requirements such as to the SEC, the emergence of a whistleblower, consumer complaints, so on and so forth. Again, don't rush to report things to the Bureau per se. We don't want you to admit any liability or admission of guilt. But that's one of the tools that they're one of the factors that they'll take into consideration in deciding how they're going to proceed with an enforcement action if they decide to at all. Third factor that they'll take into consideration is remediation, and Patty hit that one hard. The consumer complaints that you get, and I've got personal experience with this from my time at the AG's office, most of the investigations that we opened while I was at the Attorney General's office in Ohio was due to the fact that companies did not address the complaints before they came to us. I'll echo everything that Patty said there. So the remediation factor is what efforts are you going to take to resolve those complaints when they come to you before the government steps in and makes you do so. Questions that they'll ask with respect to that. What steps did the party take upon learning of potential misconduct? Did it immediately stop the conduct? How long after the conduct was uncovered did it take to implement an effective response? If the party is a business, were there consequences imposed on the individuals responsible for the misconduct? One of the things that I think is critical in your compliance management system is that you have documented consequences for internal violations of those compliance policies. And that if it gets to the point where disciplinary action is needed, that you document that it's in fact taken and when it was taken and the reason why it was taken.
Couple of minutes, Sean.
They'll look at whether or not you as a company have taken action to keep the information that might be necessary in any investigation or enforcement action. Did you identify the extent of the harm to the consumers? What assurances are there that misconduct is unlikely to recur? And so on and so forth. The last factor that the CFPB tells us that they're going to take into consideration in their enforcement actions is your cooperation or our cooperation with them in the course of their investigation. So certainly there's things that we can do to cooperate beforehand, but afterwards, after the investigation's begun, what are we going to do to cooperate? Here's some questions that they say that they will ask or they'll consider in the cooperation prong. Did the party cooperate promptly and completely with the Bureau and other appropriate regulatory and law enforcement bodies? Was the cooperation present through the course of the investigation? Did the actor identify any additional related misconduct likely to have occurred? What steps were taken to develop the truth quickly and completely and to fully share those findings with the Bureau? And did the party promptly make available to the Bureau the results of its review and provide sufficient documentation relative to what they found? Again, this is literally hot off the press as of yesterday. There's a lot of things that we'll need to digest, and we'll encourage you to digest with your counsel to the extent that this applies to you. But I can tell you that the idea of self-policing, self-reporting is a positive step, and I'm glad that the Bureau's recognized that there's a place in their investigations for that. This is the why. This is why we preach compliance like we do. This is why this panel is up here, so that you can, if somebody ever knocks on your door, you can throw this stuff in front of them and say, we're doing it. We're doing it well, notwithstanding complaints that may come in the door. We are taking this stuff seriously, and all of that will help resolve those issues with not only the CFPB, but other regulators as well.
Thanks, Sean. Rob, I think I'll turn it over to you and Cheryl to finish up. You just divide the remaining time. But I got to say, we can't finish today without Cheryl describing her plane ride out here last night.
Wouldn't miss it for the world.
My name's Rob Sickles. I'm a partner with Henshaw & Culbertson's Tampa office. I'm the outside general counsel for the Florida Independent Auto Dealers Association and represent probably over 200 dealers all over the state of Florida. I also represent some banks and finance companies that are involved with dealers. And I think one of the key components to maintaining a healthy compliance program and, more importantly, a risk management program is the consideration of the use of an arbitration agreement. There's been some recent decisions regarding arbitration and class actions. There's two interesting decisions I'll get to in a moment. So it's also a relevant topic based on just stuff that's happened recently over the past couple of weeks. Now, I'm sure you're all aware of arbitration. It's a process through which a neutral third party outside of the presence of a courtroom or a jury makes a decision regarding a controversy that arises between a consumer and a dealer. Now, there are a couple of different organizations that offer arbitration services, but they're not required. You can hire virtually anyone to arbitrate. And if you're using a form arbitration agreement, you should pay some attention to the method and manner by which an arbitrator can be selected, who that arbitrator can be. For example, some arbitration agreements say that it has to be a retired judge or an attorney. Others are silent on that. So you could really have anyone fill the role of an arbitrator. The filing fees associated with AAA are another major consideration. Right now, the American Arbitration Association in May or June increased their filing fees for businesses to $3,000. So if someone makes a claim against you, they pay a $450 filing fee, the consumer pays that. That can be waived under certain circumstances under AAA's rules. The business then has to pay $3,000 to proceed. And if you don't, they won't take your case to arbitration. Now, it's interesting because a lot of my clients think the presence of an arbitration agreement deters plaintiffs from bringing frivolous claims or bringing claims that they think might have some jury appeal, but if you look at the legal side of things, they're not going to survive. This increase in the fees has complicated that situation greatly because now a plaintiff's attorney gets in a case, it's a bad case, they've got an arbitration agreement, so they go file in AAA, and then they'll respond and say, just pay me the $3,000 and we'll go away. So by creating this $3,000 filing fee, AAA has made every case that you're going to arbitrate worth $3,000 because you can pay $3,000 and get out, or you can pay $3,000 and maybe have an uncertain result. In addition, there could be arbitrator compensation on top of that $3,000, so the $3,000 doesn't buy you a full case. It gets you the opportunity to proceed in arbitration. More importantly, as a client of mine recently found out, once that case is filed and there's a period of time, I believe it's either 5 or 10 days, they resolve the dispute for $3,000 to the claimant. They then got a bill from AAA for $1,500. So they didn't pay AAA the $3,000 fee, they got a bill for $1,500, and I contacted AAA and said, look, we didn't use your services, the case settled, what's the $1,500 fee for? It's an additional fee they now charge if a case is settled. So there's a window when you first get it that you can settle the case without paying any fee, but if it goes beyond, it's either 10 or 15 days, AAA is going to come back and bill you $1,500. If you don't pay them, they will say they are not going to arbitrate any more of your cases. So the cost factor of arbitration can't be overlooked because I think this is going to be an increasing problem. And I know some plaintiffs' attorneys who now they just routinely file in arbitration in order to leverage that $3,000 settlement. Now, some other differences that exist between arbitration and court cases, appeals in arbitration are extremely limited. Essentially, you have to show that there was fraud on the part of the arbitrator, that he was prejudiced in some way, bribery works, something like that. Even if he disregards the law, there's some case law out there that say you can't touch that arbitration decision because you've agreed to let this neutral third party make that decision for you. The interesting thing that I've seen in some arbitration agreements is a provision that says you can appeal this case, either party can appeal this case if the award is zero or the award exceeds $100,000. And in fact, this was in a franchise dealer I represent, he's a Chevy dealer, and it was in his arbitration agreement. And I said to him, how many cars do you have in this lot that are over $100,000? He said, none. I said, well, when is anybody going to be awarded $100,000 against you in arbitration? He says, well, probably never. Because in Florida, attorney's fees are awarded by the court after the arbitration. So the only thing they get in arbitration is damages. So he's never going to take advantage of that appeals process. But then if you look at it on the other side, what case are you likely going to get a final hearing in an arbitration on? One where you don't have liability. Because if you have liability, you're probably going to try to settle it or work something out with the plaintiff to resolve it. So you are saying you get an automatic right to appeal if you're given nothing. And your appellate rights on a 3-arbitrator panel. So if you think about that rationally, you have a frivolous case or a case you know you can defend. You go through the arbitration process, you win. Now that plaintiff gets to go get another shot at it with a three arbitrator panel. Under this agreement, the plaintiff actually had to pay those fees, though, so the dealer didn't have to pay those fees. But now you've got to do it all over again. There's no requirement that those types of provisions be in there. So if it's in your arbitration agreement, it might be something you want to consider taking out. Florida has a bad case that came out recently that says if your retail installment sales contract is a fully integrated document, you are required to have your arbitration provision in that document, otherwise it's not enforceable. So if you're using a standalone agreement, at least in Florida, you can run into problems getting it enforced. Adding to the complications there is if you assign your retail installment sale contracts to third parties and it has the standard assignment language that's at the bottom, it says the dealer assigns all rights and interest in the agreement, including the arbitration provision, to the bank. There's an argument to be made, and I haven't seen it made by anyone yet, but that by assigning that arbitration agreement, the dealer no longer has the rights to enforce that arbitration agreement. So I always, despite that case, keep a standalone agreement in most of my clients' files or put something in their buyer's order that says arbitration will be used. Hopefully that case will be examined by an appellate court in a different light, and they'll recognize that you sign about 30 different documents when you do a deal file. I mean, if you stand it on its head, if the consumer was trying to enforce a warranty that was a separate document, I don't think the court would have said, well, because this isn't in the retail installment sales contract, it's not enforceable. So it was kind of a results-oriented decision. With respect to the two cases I just mentioned regarding arbitration that the Supreme Court came out with, one was released on June 10th. It's called Oxford Health Plans versus Sutter. And this case is important because in this case, the Supreme Court put class arbitration back on the table, in its manner of speaking. Because what happened was, the parties had an arbitration agreement, they enforced it. They decided that the arbitrator could decide whether or not the action could proceed as a class. The arbitrator said, yes, I think class arbitration would be wonderful. I'll be busy for the next 2 years, have a lot of stuff to do. So he certifies the arbitration as a class, and they proceed. Well, in the interim, the United States Supreme Court have come out with a decision that says unless your agreement specifically allows for class arbitration, you can't have it. So the dealer or the defendant in that case attacked the ruling by the arbitrator that there was going to be a class arbitration, went all the way up to the Supreme Court. The Supreme Court said, look, you guys have said that the arbitrator gets to decide this issue, and we can't touch the arbitrator's decision even if he's disregarded the law. You agreed to let him do this, so as a result, he gets to go forward with class arbitration. And they said this doesn't change the law before, this just says if the arbitrator makes that decision, then you're stuck with the appellate rights that you have in arbitration, which are limited. Then following that case, on June 20th, the Supreme Court came back with a decision in American Express versus Italian Colors. In that case, the party that was opposing arbitration was saying it's too expensive to arbitrate an antitrust case on individual damages alone. And they had an expert come in and he said it would cost about $1 million to present their case. And they opposed arbitration on that and said we need to be able to do this as a class. And the Supreme Court did a rigorous analysis of the precedents and the case law and everything relating to arbitration. And they said, look, there is no right to have a class action in an arbitration simply because your damages may be too small to warrant bringing the action. It doesn't eliminate your ability to bring the action. You're just making a decision not to do it. So hopefully that's the final word now on class arbitration, because I know after the June 10th decision came out, a lot of people were saying, well, what does this mean? Does this change anything? I think the Supreme Court's clear now that unless your arbitration agreement specifically authorizes a class arbitration, you can't have it. How much time? I don't want to.
Oh, you're fine.
Okay. Now, everybody's been talking that the CFPB may be looking at maybe looking at arbitration agreements in consumer situations. That's absolutely true. They're doing a study to determine the impacts of consumer arbitrations and how consumer rights are affected in consumer arbitrations. The last I had read, I think it was in April or May, they were planning on doing a survey of a statistically significant sample of consumers to get their experience with arbitration, how they've handled them, how they've worked out. And to be honest, I think a lot of this stems from the investigation that was done in Minnesota by the Attorney General of an arbitration situation where the arbitrators were also affiliated with the plaintiffs, and it was just, anybody that looked at it knew it was an unreasonable and unworkable situation. I don't know who thought it was a good idea to do it that way, but because of that, the idea of consumer arbitrations has been tainted. And with that, I'll turn it over to Cheryl.
Well, good morning, everybody. My name is Cheryl Wilkie. I'm Rob Sickles' partner. I work out of the Fort Lauderdale and Los Angeles offices of Henshaw. And as a result, I fly a lot. I'm the token employment lawyer. I went to law school, unlike these people, because I'm not that smart and I don't do math. So as an employment lawyer and someone who practices bi-coastal, I fly a lot, 150 days a year. And this is the second year I've had the privilege of speaking before this group. And yesterday, when I came out here, I had my usual flight from Fort Lauderdale to Atlanta, no problems, easy peasy. And then I get on my plane to come out here, and I notice that the people getting on the plane seem to know each other. Okay. They all seem to have the same accent, and they all seem to be having a wonderful time. And as I get on the plane and I sit down, and the nice gentleman who sits next to me, and he starts talking to me like I am his long-lost friend, and I said, "I'm sorry, I'm not following." And he says, "Well, you're with the group, right?" And I said, "Sir, I'm sorry, I'm going out to the NIADA conference. Is that who you're with?" And he said, "Well, no." And I said, "Well, what are you going out for?" He says, "Well, there's 120 of us, and we're franchisees of Hooters, and we're all going out to our conference." Now, as reported earlier, I can attest that Stephen Hawking was not on that plane. And it was a very long 3 hours and 40 minutes from Atlanta to here. And if I thought, having been here last year, that you all know how to have a great time. I love this group. You have nothing on those Hooters folks. According to the flight attendant, there was just over $3,000 worth of alcohol sold on 3 hours and 40-minute flight from Atlanta to Las Vegas for our wonderful friends who run Hooters franchises. So if you ever decide to get out of the auto business, that may be an option. Now, I try to get you all in a good mood because I'm here to talk about the thing that nobody wants to talk about, which is the Affordable Care Act. And I know, please don't throw things at me. As an employment lawyer, I'm going to talk to you a little bit today from 3,000 feet about this act and how from a regulatory standpoint it impacts you. But let's start with the good news. How many of you here have 25 employees or less, or have less than $500,000 a year in payroll? Okay, cool beans, you don't have to listen anymore. Okay, because the mandates do not apply to you. Now here, for those of you who are still listening with the 25 employees or less, here's the good news. Should you choose to provide coverage, if you wish to, you can actually get a small business tax credit, and if you have less than 10 employees, that tax credit is 50% of your insurance premiums. So let's just walk through that for a second. Again, I went to law school because there was no math. I'm not as smart as these people. But let's say you've got 9 employees, and you decide to provide coverage. You're a family business, you want coverage, you do that. Your annual premiums are, let's just use round numbers, $15,000. You can actually apply for and get a tax credit through 2016 of $7,500, which is a tax credit because you have decided to do this. Well, gosh, that sounds interesting. Now, the tax credit itself is decreasing. So the more employees you have, the smaller the percentage, although the dollars may be the same, the smaller the percentage of the tax credit that you get for the premiums. So that's for those of you with 25 employees or $500,000 in payroll or less. So far, so good. So let's get to the tough stuff, okay? If you have more than 50 employees, and I want to be very careful about this because this is the first federal law that has ever defined what a full-time employee is. Forever, states may define part-time versus full-time, but the federal government never did. Basically, employers had the right to choose whether that was 20 hours a week or 15 or 4, nobody cared. Now it's 30 hours. 30 hours is your cutoff. So if you have 50 employees who work 30 hours or more, you are covered by the ACA, by the Affordable Care Act. Well, what do you have to do? Well, you have to offer insurance to those who work 30 hours per week or more. The insurance must cover a core set of benefits, which includes lifetime benefits for certain conditions, and also requires that you provide coverage for dependents. Now, I grew up in the Midwest. My parents own a dairy farm in northern Michigan, and we make cheese. And so again, I'm a misfit on so many different levels. But when my mother very graciously kicked me out of the house at 17 and said, go to college, she meant it. And I got on a plane and I went to Florida and I went to college. Well, you'll be pleased to know that under this CARE Act, dependents can exist until 26 years old. So you can actually, as an employer, be required to pay for your employees' dependents who are 25 years old and still living at home and financially dependent, which I think what they really should do is just send them to Irene Wilkie in Pinconning, Michigan. That's my mom, and I'm sure she'll straighten them out in a matter of moments. But that's really what it says. And the other thing is, and this is where it gets really tricky, and again, I'm going to try not to get too terribly technical, but it says that the coverage that you provide as an employer has to be affordable to the employee. Well, what does that mean? They've defined it as 9.5% of the employee's income, of their payroll. So the premiums that you charge to your employee cannot be more than 9.5%. Well, that might work fine for your $40,000, $50,000, $60,000 a year employees, but for your frontline minimum wage employees, it's going to be really difficult to do that. So what happens if you can't provide it to them? Well, they've created a system within this called the exchange program, and each state is supposed to be setting up this exchange where people who are underprivileged or have these kind of salaries, minimum wage salaries, can get insurance through the state. Well, that's all well and good, but if your coverage as an employer is not affordable, meaning that you have some employees who it's going to be more than 9.5%, the premiums will be more than 9.5%, they get to go to the state, get the coverage, and then the state charges you back $2,000 per employee, because you're renting insurance from the state effectively. Now, I was talking to another one of your esteemed attorneys this morning, and he said, yeah, Cheryl, but 32 states have opted out of this exchange. They don't want to do this. Well, that's true, but how many of you are old enough to remember, because I am, although you're supposed to say, Cheryl, you don't look old enough to know this, but how many of you are old enough to remember when they first passed the 55-mile-an-hour speed limit? Okay, and do you remember that there were all those square states out here that said, we ain't going to do it, we don't care, states like Montana and Wyoming who said, we don't care what you do. And the federal government said, that's fine, you can keep your speed limits wherever you want. That's perfectly okay. We will give you not one dime for roads. No problem. You will never get another bridge, you will never get your freeways fixed, have a nice time. So what they've done with this mandate is those states who folded their arms and said, we're not going to do this, we are not health insurers, we're not getting into this business, they're saying, that's fine, you will get no more Medicare dollars. Good luck taking care of the people in your state. So even though there's 32 states who are kind of sitting on their hands right now, history indicates that eventually all the states are simply not going to have a chance financially. They're going to have to get involved. A few other points. If you're an employer with more than 200 employees, you not only have a duty to provide the coverage, but you must enroll them. Each of your employees must be enrolled. Now, one of the questions that I get a lot from mid-sized employers like you all is, well, Cheryl, what if I give the coverage and my employee doesn't want it? That's fine. They don't have to take it. Here's what happens. In 2014, and if an employee qualifies for a health, they're not one of those people who has 9.5, they actually are considered a regular wage earner within the program, and they choose not to participate. They get charged $95 in 2014. Okay, no big deal. In 2016, that goes up to $695. So the employees actually now are going, again, back to this exchanging thing. We're all going to go back to the states are going to run this. And so the employees can make that decision, but it's going to be painful. So if an employer chooses not, and a 50-employee employer chooses not to provide any coverage at all, then you have to pay the $2,000 up to $3,000 depending on certain factors for all of your employees over 30. I have had lots of employers sit down and do the math and say, you know what, we've only got 55 employees, we're not a high wage earning company, this works for us, we're going to do this. That is perfectly okay.
2 minutes, Cheryl.
You do not get to deduct that money like you would regular health insurance premiums. That is not a tax deductible figure. Federal government's trying to fix that. And the last point that I would raise, and the most important, I think, is I've raised a lot of numbers, but I'm going to give you one more number if y'all want to write this down. It's 954-467-7900. That's my telephone number. Because there is no way I can tell you everything you need to know about the Obama the Affordable Care Act in 12 minutes, notwithstanding what Tom thinks I can do. So please call me if you have any questions. Thank you very much for letting me participate.
Okay, we're going to go to Q&A here in a minute or two, and I want you to be thinking about questions that you want to ask. Joe, you're going to you got the microphone. We'll ask you to hold your questions until you have a microphone in front of you so that everybody in the room can hear what you want to ask. And if your question is to a specific panel member, please mention the panel member. While you're thinking of the questions you want to ask, I will say we've gone to school here this morning, and at least I learned, I tried to jot down one line from each one of our speakers, and from Patty I learned that those compliance management systems are something that we got to have now. It's not just a good idea anymore, it's a must-have. From Mike, we learned that you're not really paranoid because plaintiffs' lawyers really are out to get you, and they've got ways to do it, and Mike came up with some good defenses that are available. Lisa says, her mother says, treat folks right, and for years and years and years, I told dealers that was compliance rule number one. I think it's still incredibly important, the difference, of course, being that with the CFPB, not only do you have to treat folks right, you have to be able to show that you've got a process in place for treating folks right. So Sean told us that Washington's not your friend, but he also told us that self-policing can be your friend, and when it comes time for an attack from the CFPB, a self-policing program can be very useful. I think Sean said that was hot stuff off the news last night. He'll know more after he's had a chance to read it, and I'm sure we'll hear more from that in the future. From Rob, Rob talked about arbitration, which is one of my favorite topics, and arbitration certainly is your friend, but like a number of these things, you got to do it right. And from Lisa, I heard fire some employees and avoid the Obama health care. No, that's not quite what I heard. Good practical advice on the Affordable Care Act. With that, we'll entertain some questions, if you have any. Yes, sir, down here. Joe, hustle, man.
Thank you. The question is for Cheryl, Affordable Care Act. Is there a white paper out there, actually two-part question, is there a white paper out there that makes it understandable to people who are even less bright than you?
Well, yeah.
Okay.
Actually, there's two that I recommend. The first one is the one that the Chamber of Commerce puts out. Just go into the website for the U.S. Chamber of Commerce. They have a very, very good summary of it. The second, and the one that's a little bit more complicated, but I believe will give you the most unbiased opinion, strangely enough, because it is just truly a summary of the law, is the Office of Management and Budget for the federal government. And you can go onto their website, and they actually have it in a question and answer format, which I think is very good. For your benefit, I really do think the Chamber of Commerce probably does the best job of summarizing and providing you with the appropriate resources.
Okay, second question, when counting the 50 employees, you have two legal entities, one with 25, one with 25. They're really involved in the same business. Is there any effort to pierce that?
Oh boy, yes. Thank you for asking that. That's one of those topics I did not have enough time to discuss. But absolutely, if there is common ownership, and that's defined as part of the statute. So if you have a finance company that's owned by three principals, and you have your auto dealership, which is owned by two of those three principals, that is going to be considered common ownership, and all of those employees are going to be incorporated for the purpose of the plan.
Okay, Georgia next.
Yes.
Sorry. Oh, this guy's just, this poor guy in the black shirt, he's just going to throw things at me. I know he is. He's just so mad. I'm sorry.
My question would be for Rob Sickles on arbitration. You gave us the figures about the filing fee of $3,000. Can you kind of give me a minimum attorney fees, this, that, and the other, even if the dealer comes out the winner, it's going to be kind of pricey, isn't it?
It could be, because you're not required to, but likely you're going to hire a lawyer to handle the arbitration. I mean, you can show up yourself and do it yourself if you wanted to. And then most of the statutes you're getting sued under are going to have some type of a fee shifting, at least in a consumer situation, arrangement in them. So that's what they're going to be looking for at the end of the day. But as I mentioned, in Florida, the courts award those fees. AAA does have in their consumer supplement a provision that says if the claim is worth less than $10,000, neither side is guaranteed a hearing. You can ask for a hearing, Otherwise, it'll be just decided on paper submissions. So you file some affidavits and your documents, they do the same thing. It's not always the dealer's advantage to do it that way, even though it can be substantially cheaper, because many times when you get a demand in arbitration, it just simply says the consumer wants $10,000 for unfair trade practices, and that's all the details you get. So until you actually see their submission, you don't even know what it is they're claiming in some instances if you're doing a paper submission, because you're not guaranteed discovery in arbitration either. So, I mean, to handle an arbitration, you can go anywhere. I mean, I had a client that had an arbitration over a $25,000 car, and they spent $30,000 arbitrating between arbitrators' fees, attorneys' fees, and everything else. They won, but it would have been way cheaper to sell the thing. So cost obviously does have a role to play in that decision. My focus was more on the fact that plaintiffs' lawyers are now looking at this as a free $3,000 because you've got to pay that to have it administered.
Courts regularly reward attorney's fees in these plaintiffs' cases that dwarf any statutory damages fees. And you got to remember, on top of paying the plaintiff's attorneys, you also have to pay your own. So those numbers can really be big. Joe?
My question is for Cheryl. I heard your comments on the common ownership through these holding companies trying to create these LLCs to get that employee thing down, and I understand that. But is the government going to take, if we try to manage the 30-hour thing and go to that area, are they going to be averaging those averages and then put them into full-time, or what's going on with that 30-hour thing?
That's a great question about the 30 hours. They're going to do this through your payroll taxes, through your state payroll taxes. So it's actually going to be, they're going to be monitoring the states. Now, I have the privilege of speaking with many of you, give me telephone calls and ask me questions. And one of my good friends in your group called me from the great state of Illinois, which is a very regulated state, and said, well, Cheryl, I'm just going to make them all independent contractors. And I said, well, that's fine, except the state of Illinois and the state of Indiana, as well as several other I states, those little states in the middle of the country, they're actually going in, sir, and they're auditing. They're doing W-2 audits to determine how much you're paying them, how you're paying them, how it's calculated, and then, of course, it all ties in with the Fair Labor Standards Act as to whether or not they're being paid the proper salary per hour. So yes, I do think it's going to be monitored, not so much by the federal government, but by the states, because the states want you to do this so that these employees do not end up in these state programs.
Joe, here.
So I heard a lot of discussion about complaints and how the number of complaints you have play into a CFB review. But it didn't sound like we were specific on the type of complaints. Now, I understand, if F&I does something wrong, or if you have personal information going out, those are all compliance type complaints. But if I have a guy that buys a car and 6 months later decides I should have put new tires on it, he buys it himself and says he wants me to reimburse him, are those types of complaints being considered by the board when they're looking at how to handle things, or if they want to look?
How about Patty and Sean here?
Do you mean to, the interesting thing about complaints, the CFPB's complaint database, they have an interactive database where a consumer can log the complaint, and now the company that is subject to the complaint has to contact the consumer, resolve the complaint, and then report their resolution back to the CFPB. So it gets uploaded to a portal that the CFPB has with those companies. The CFPB will then go back to the consumer and ask the consumer, were you happy with how the complaint was resolved? And the consumer will say yes or no. So to get on the CFPB's radar, there's really two ways, because they have this consumer response team that goes back and investigates and reviews the complaints. The first is if you don't respond to the complaint in a timely manner. So they have a time frame that you're supposed to respond. It's like 15 days. It used to be 10. And if you don't respond in that time frame, then you potentially could get on the CFPB's radar. The second is if the consumer was not happy with how the complaint was resolved. And at that point, the CFPB is going to look into it. That doesn't necessarily mean it's going to get you into trouble, because it could be, like you point out, the customer wanted new tires, and it's not really a complaint on the consumer financial product or service, and they're going to discard those. But to the extent that they think there is some merit there as to the consumer, they're trying to be a little bit more reasonable. And I think that they've learned a little bit over the last year and a half. Well, it'll be 2 years in July, the 21st of July. So they have learned a lot. They've gotten a little bit more educated that consumers log silly complaints, stupid complaints even. And so they're getting more reasonable, but you can get on their radar now, which I think is a good point, with a onesie, what I call onesie and twosie complaints, as opposed to, generally it used to be you have to kind of have a critical mass to get on a regulator's radar. Now onesies and twosies can get you there.
Sean?
And that's one of the concerns that we had that you brought up was with this complaint database and the fact that it is public, how is the Bureau going to handle complaints that they don't have jurisdiction over, such as the tire issue? Certainly they do over the financial product, but kicking the tires and the actual mechanics of the car itself is something they don't have jurisdiction over, and we would have some concern if they started to use that as a basis. But I don't think they will. They've been pretty good at, as Patty said, kicking those out.
Yeah, the question you're getting at really is what's the definition of a complaint? And the Bureau hasn't defined that term yet in writing that I know of. I did manage to get a definition out of Rick Hackett when I interviewed him a couple of weeks back, and I'll share that with NIADA and others, and I'm sorry I didn't memorize it at the time. But we'll get that out to you. We'll let you know what the Bureau at least thinks a complaint is. But it's important for your organization to identify, to have a definition for what your organization considers to be a complaint, a well thought through definition that you check with your lawyer on.
One thing, and I'll also share, on complaints, is that database is being shared with the state regulators. So that is, if the CFPB doesn't pick it up, a state regulator could.
And the FTC.
And absolutely the FTC.
Okay, Joe?
Lisa, you touched on the cash or credit price. Now, we have customers that come in and pay with credit card, and we have a cash price. And if they run out their credit card or hand out their credit card, now we're bound to pay another 3%, 3 to 4% because they've got a credit card. How can we address that? Much like the service stations are doing it all over the United States, you have your cash price or your credit price. How can we protect ourselves?
Well, there's a little bit of a difference in what you're saying. There's one thing to be paying with an installment on a credit card. There's another thing to be having the sales price change. My focus is on the sales price. It needs to be the same no matter what, whether you're paying cash or credit. That amount should not change. Now, you can charge people, again, though, anything you charge for credit, in addition to that sales price, is going to be considered a finance charge unless you can somehow prove otherwise. Proving otherwise is very difficult. So pick a price, put it on that car, and stick with it. That's my best advice.
What you're talking about, I think, is surcharging a cash price in order to accommodate the credit card company's fee to you. Right?
Exactly.
If you'll just, anybody who wants to answer to this, just put credit card rules on the back of a business card, give it to me. I've got an article that's one of my partners did that's 3 or 4 months old that I can send around to you.
And some states do have laws that you can't charge a surcharge, and those they're starting to pick up a little bit of steam. So you'll see some legislation on the state side on that. Right.
Who? Jordan? Okay, I'm told we're out of time. I want to thank all of our panelists, and if you'll join me in giving them a round of applause.